Hi there everyone, it's Jim Filippi with the Filippi Law Firm. Today I'm going to talk about all of the different types of documents that are contained within a comprehensive estate plan. An estate plan covers all aspects of your life. Not only dealing with just what happens when you die, but it also deals with issues that could happen to you while you're alive, primarily if you become incapacitated through some sort of injury or illness. And when we talk about a comprehensive estate plan, when we deal with what happens when you die, we're talking about typically a living trust and a will that's there to support the living trust. And together, those documents will control what happens with your assets when you die, who's going to get them, how they're going to get them, over what period of time they're going to get them, and a whole lot of other opportunity for some customization should you want to do something very special. So that deals with what happens when you die, the living trust, and the will. When we talk about what happens if you become ill or incapacitated, we're talking about a financial power of attorney and advanced healthcare directive. So when we're talking about the financial side of it, I draft two documents, a general durable power of attorney, and that is a very comprehensive attorney drafted document that covers almost everything that could possibly happen to you and grants those powers that are needed to the person you've designated so that they can take actions on your behalf. I follow that up with a backup document that's called a California Statutory Form Power of Attorney. Now that's a lot of words for, it's a fill-in-the-blank type power of attorney document. The reason I add that one to a comprehensive estate plan is because that is very readily recognizable by those people that are working in certain financial institutions, that they're not going to lock up and freak out when they see the attorney drafted power of attorney that I just talked about. They're going to see this California statutory form power of attorney, and they're going to recognize it and realize what it is. Now, of course, we customize that to a certain level so that it is as comprehensive as we possibly can while staying within the law, but we make sure that if something happens to you, whomever you've designated has the ability to walk into the bank or whatever they have to do on your behalf with both documents and say, I need to do X, Y, and Z, and present both of those documents. And hopefully without too much of a delay, they'll be able to get that transaction taken care of on your behalf. Now, when we talk about your healthcare documents, there's two documents that we draft. We do the Advanced Healthcare Directive, which gives the authority to someone to make your healthcare decisions if you're not able to make those yourself. And then it also gives instructions on how those decisions should be made. So you're not going to be speechless when it comes to making those type of decisions. Those are important personal decisions, and of course you should have a say in how that goes. And an Advanced Healthcare Directive gives you that opportunity to have a voice in what happens to you. The other healthcare document we draft is called a HIPAA Authorization. That is a federal law that deals with privacy when it comes to your health care. And as you probably know, if you've been to the doctor, you've likely seen HIPAA advisements and signed documents dealing with HIPAA. And in a nutshell, HIPAA just basically says that your healthcare information is private, personal to you, and no one has access unless you've given them permission to have access. And so what the HIPAA authorization does is give those people that are going to serve on your behalf specific authority to get that healthcare information so they can make the decisions that are needed. We finalize that up with a nomination of conservatorship. So while we try to address all the possibilities that could occur that would require a conservatorship and attempt to avoid the conservatorship with both the durable power of attorneys and the healthcare documents, there's nothing that's 100% guaranteed. There's nothing that is 100% guaranteed. In the reality with our human existence, there's no document that can address every possibility. So what we do is we also give you the opportunity to name the person you feel more comfortable with as serving as your conservator. So if something's happened to you, you get an opportunity to speak on who's going to be appointed by the court. That is the main documents that are included in an estate plan. We also draft certain things like an assignment of personal property, a declaration of trust, your schedules of assets, and we make sure, grant deeds of transferring assets into the name of the trust, and all of those documents deal with the assets and making sure that both the assets get placed into your living trust, and also that the trust is fully recognized by a court if it's ever called into question. So that's everything that's in a comprehensive plan. Not everybody needs everything. Most of us do, but there are certain people that may not need a full comprehensive plan. It's not a one-size-fits-all. That's why I think it's important for everyone to sit down with an estate planning attorney such as myself and figure out what exactly you need for your particular situation. And we're always here to help with that if you choose. So an estate plan has a living trust, a last will and testament, a general durable power of attorney, most often a California statutory form power of attorney, an advanced healthcare directive, a HIPAA authorization, and a nomination of conservatorship, along with some other what we call ancillary documents such as an assignment of personal property, a declaration of trust, personal property memorandum, and grant deeds that would place real property like your house into the trust.